Hello there and welcome to another edition of Biz First in Focus. We're coming to you from our Newsfirst studios here in Colombo. Generally, we speak about policy issues and other issues surrounding business here in Sri Lanka. Today, we have decided to direct our focus onto a different aspect of business. Labor laws is an important aspect when it comes among the business community, especially in the private sector. And to discuss a bit of a general overview on the labor laws here in Sri Lanka, we have in our studios with us today a senior lecturer at the Faculty of Law, the University of Colombo, and a visiting lecturer at Sri Lanka Law College on labor law, attorney at law A. Sarveswaran. Very good evening, sir, and welcome to the show.
Very good evening.
Sir, speaking a bit of the general overview about the labor laws here in Sri Lanka, how complex are the labor laws here in Sri Lanka, and how much have we got on our plate really?
Yeah, when it comes to Sri Lanka, we have about 35 legislation, but some labor laws have been, some labor statutes have been enacted to deal with labor matters, but there are many laws which have been enacted for different purposes, but they also become relevant to labor law. But when it comes to Sri Lanka, it is very complex, because the complex in the sense, I will give an example. So we will take a tea estate in Hatton. So if we take a tea estate in Hatton, and we will say the plantation is there, tea plantation, and also there is a tea factory, and the tea factory has an office, and also there is a tea shop. So within one place, we have 4 categories of employees. The workers who work in the tea plantation, the tea pluckers, the workers who work in the tea factory, the workers who work in the office of the tea factory, the workers who work in the tea shop. So when it comes to these 4 categories of people, all come under the private sector, but we have different labor laws. For example, when it comes to the workers who work in the office of the factory, and also the workers who work in the tea shop, they all come under the Shop and Office Employees Act when it comes to their terms and conditions of employment, mainly working hours, overtime payment, and their leave entitlement and all. When it comes to the factory workers, they come under the Wages Board's ordinance. So when it comes to the wages boards also, we have about 44 wages boards. So different decisions. When it comes to the workers who work as tea pluckers in the tea estate, they don't come under any of these laws. So then within one place, we have different categories of workers, and we have different labor laws. So it is very complicated, because actually I would say we have to consolidate. We have to, there are so many labor laws which have become obsolete now.
Right.
And also we have to consolidate all these laws into one and have a single law to apply to all workers. For example, when it comes to maternity leave, when it comes to the female workers who work in the shop and the office they all come under the Shop and Office Employees Act. So under that, they get 84 working days. So for now, actually, after the 2018 amendment, so the employees, the female workers who come under the Shop and Office Employees Act are entitled to 84 working days, irrespective of number of children. But when it comes to the female workers who work in the factory, they all come under the maternity benefits ordinance. There it is 12 weeks, including holidays and all. So the problem is, so why do we need 2 different laws? So why can't we apply the same law to all workers? So I would say now the time has come to revisit to the labor laws. And I would say we have to go for a single law. But it doesn't mean we can bring all labor matters under one law, but we have to minimize the number of labor laws.
So when it comes to other countries and how they have dealt with labor laws, have they consolidated these laws, and is Sri Lanka following on a similar path?
No, actually when it comes to most of the other countries also, they have the same problem. But anyway, they also reduce the number of labor laws. And also there are many changes that are taking place also when it comes to the forms of the contract of employment. But actually those days, the law was dominating. The technology was lagging behind the law. But now
it's the other way around.
It is the other way around. So now we have to go introduce the changes according to the developments in technology.
So also a common perception among the general public is the fact that you need a letter of employment to be confirmed as an employee or to have an agreement with someone else to work. Is this true, and how far true is this?
It's a good question, because when it comes to Sri Lanka, when it comes to these labor laws, there is no legal requirement to have a written letter of appointment to create employer-employee relationship.
Okay.
But when it comes to the Shop and Office Employees Act, there is a provision which requires the employers to give a letter of appointment.
Okay.
But even though the employer has not given the letter of appointment, still the relationship will continue.
Okay.
So, when it comes to Sri Lanka, I would say there is no mandatory legal requirement to have a written letter of appointment. Without letter of appointment, the relationship could exist. For an example, when it comes to a shop, right? So, the owner of the shop has not given the letter of appointment. So, doesn't mean the employer need not contribute for EPF, ETF and all.
Okay.
Whether he has given the letter of appointment or not, they are employees. So, the relationship exists
And the existence of that relationship will be determined by courts.
by courts and by the labor commissioners.
Right. But also, when speaking about employees, there is this period of probation that we speak about, and during this probationary period, we know that the employer can terminate the employment of the employee at any given time. When it comes to this probationary period, there were certain issues in the past as well where these industries or companies continue to employ these people under probationary contracts. Is this legal, and how far can this last?
No, actually, when it comes to the private sector,
Okay.
but generally it is 6 months, the probationary period, but it could be extended. It can, in some places it could be nine months or in 1 year also, but there's no specific period. Right?
Okay.
But the probationary period means during the probationary period, the employer will assess the employee and decide whether the employee is suitable to the job. But it does not mean the employer can take any decision at the end of the probationary period. No.
Okay.
Because if the probationer has satisfactorily completed the probationary period, then the employer has no choice. The employee should be confirmed, because now when it comes to the job security of the probationers, so they also have job security. Because if the termination is a mala fide termination with bad intention
Okay.
or victimization, then the probationer can go to a labor tribunal and seek relief. So they also have job security.
We'll cross over to a short commercial break and continue this discussion on the other side. Don't go anywhere. You're watching BizFirst in Focus. Welcome back. You're watching BizFirst in Focus. We're in discussion about labor laws here in Sri Lanka, especially labor laws that affect the private sector. Sir, we were speaking about job security of probationers. Let's speak a little bit about job security of private sector employees in general here in Sri Lanka. Is there adequate job security, and if so, what are the provisions?
So when it comes to Sri Lanka, generally I would say compared to the other countries, here in Sri Lanka the workers have job security.
Okay.
And also it is in many ways. For example, I would say now if you take the letter of appointment, in some places, so they include the clauses saying that either party can terminate the
Contract at any time.
Or by giving 1 month notice or 1 month salary in lieu of 1 month notice. We will say that employee is a permanent employee, his age of retirement is 60 years, right? He has completed the probationary period, he has already worked for 10-12 years, we will say, but he has not committed any misconduct.
Okay.
So in that situation, the employer can't suddenly give the 1 month notice according to the letter of appointment and ask the person to leave the company or the place. That he can't do, because if that happens, the employee can go to a labor tribunal and file an application against the termination.
Okay.
Because the labor tribunal is not bound by the unreasonable clauses in the letter of appointment.
Right.
So the labor tribunal president will say this clause in the letter of appointment, that is, giving 1 month notice and terminating the agreement, is an unreasonable clause.
Right.
And he will decide to reinstate the person, or he may order to pay compensation in lieu of reinstatement. So then the employees, when it comes to Sri Lanka, they have job security. Therefore, the employees have to be very, very careful at 2 points. One is at the time of recruitment.
Right.
The other one is at the time of
Making them
confirmation
permanent.
after the probationary period. So if they make mistakes at these 2 points, then it is very difficult to terminate an employee, because it is something like divorce. You can simply marry, but divorce is not that easy.
Easy. When we speak about the legal system here in Sri Lanka, a topic that always pops up is delays. And there is this popular saying that says, justice delayed is justice denied. So when it comes to labor legislation and enforcement of these legislation, how far is the delay? What's the average payback time for legal remedies?
Now, it depends on the nature of the case.
Okay.
Now, some cases are very complicated.
Right.
Sometimes there may be a case,
Involving more than one party.
one party, and also more issues.
Okay.
And also sometimes there are technical issues also.
Right.
So it depends. It depends. Sometimes it takes time also.
Okay.
Right. But I would say, because there are time limits, but those time limits in the labor statutes are not mandatory provisions.
Right.
So that means the courts can make the decisions even after that period also.
Right.
So but for an example, the workman has to go to a labor tribunal within 6 months from the date of termination.
Right.
That is mandatory.
That is mandatory.
Mandatory, because he has to go. For an example, when it comes to fundamentalized cases in Sri Lanka, the person whose rights have been violated will have to go within a month. That is mandatory. But when it comes to the courts, it is not mandatory, because you can't have it as a mandatory provision also.
It's not practical.
Not practical. But what I would say is, we have to minimize the period, and also wherever it is possible, we have to go for settlement also. We have to go for settlement, and we have to develop conciliation, mediation, that also, or in arbitration.
Okay.
We have to strengthen those mechanisms also.
I was recently in discussion with a leading lawyer in the field of intellectual property, and when he spoke about arbitration and ADR, one thing that he said is it is as the proceedings get delayed as much as average court proceedings. So ADR in Sri Lanka isn't really fulfilling its intended purposes.
Yeah, true. But we have to have, but anyway, I would say when it comes to any mechanism,
Okay.
we have advantages and disadvantages.
Right.
But anyway, we have to simplify the mechanism, and also we have to work with a time frame.
So speaking a bit, we spoke a lot about the employees. When we speak about the employer, what are the grounds that they can actually terminate the employment contract of an employee for?
There are many types. One is disciplinary termination.
Okay.
That is termination for a misconduct. Other one is non-disciplinary termination. That means retrenchment. That is reducing the number of workers who are excess in the workplace, or closure of the business. So these two come under non-disciplinary termination.
Right.
And also there could be constructive termination, vacation of post. So there are different types of termination of employment.
Right. Also, sir, when it comes to payment of gratuity and so on and so forth, is there a legal obligation on every employer to pay gratuity to contribute to the EPF, ETF, or is it only restricted if those are mentioned in the contract of employment?
No, because when it comes to these statutory benefits, whether these benefits have been mentioned in the letter of appointment or contract of employment or not, the employer will have to contribute for them. For an example, when it comes to gratuity, again we have two laws.
Okay.
So here, when it comes to gratuity, we have the Payment of Gratuity Act, enacted in 1983. So according to that act, if an employer employs 15 or more workmen, then the employee will have to pay gratuity at the time of termination,
Right.
if the employee has completed 5 years of service.
Right.
It is a mandatory requirement under the law. But if there are less than 15 workmen, then in the workplace, then the workers are not coming under the Gratuity Act.
Okay.
Then they have to go to a labor tribunal to claim gratuity.
Right.
So at the beginning, you asked me about the number of labor laws in the country, but I would ask why we need two different laws. Because when it comes to EPF, we don't see the number of workers in the workplace.
That's not counted.
Yeah, whether there's one workman or 500 or 50 or whatever number.
Doesn't matter.
Doesn't matter. Doesn't matter. But here we see the number of workers. So likewise, when it comes to termination also, we have a legislation called the Termination Act.
Okay.
Right? There also, if there are 15 or more workmen in the workplace, then they come under the Termination Act.
If not?
If not, they will not come under the Termination Act. But one is, it should be the private sector, and also there should be 15 or more workers in the workplace, and also the workers have completed 180 days. Then they come under the Termination Act.
Right.
If not, they will not come under the Termination Act.
So we will continue this discussion after a short commercial break. Don't go anywhere. You're watching Biz First in Focus. Welcome back. You're watching Biz First in Focus. Getting back to our discussion about labor laws here in Sri Lanka. So we know that trade unions play a major part in organizing employees here in Sri Lanka. We know that more than often we, the general public, are sometimes inconvenienced because of these trade unions. But just to give a basic understanding of the legal standing of a trade union, what does a trade union exactly mean, and what are the provisions that entail?
Actually, when it comes to trade unions in Sri Lanka, we have many laws.
Right.
Basically, the employees in the government sectors,
Okay.
public sector and the semi-government sector, they have a constitutional right
To form a trade union.
to form a trade union and join in a trade union.
Right.
But when it comes to the employees in the private sector, so they also have a right to form a union and join in a trade union.
Right.
Actually, that has been incorporated into the Industrial Disputes Act by an amendment in 1999. So when it comes to Sri Lanka, only certain categories of employees can't form a trade union.
Right.
So mainly the members of the armed forces, the police officers,
Right.
judicial officers and the prison officers.
Right.
All others can have a union, trade union. But when it comes to the trade unions, even the employers also can have a trade union. There are trade unions for the employers also.
Estate employers, trade unions.
Trade unions, and there are many. There are some trade unions which are for the employers.
Okay.
Right. So when it comes to the trade unions, I would say when it comes to their trade union activities and all, as you said, they go for strike also.
Strikes.
But anyway, the strike should be the last resort.
Right.
Right? Because actually, when you go for strike, actually, before you go for strike, you have to try other mechanisms.
Right.
When all fail only, you can go for strike. But in Sri Lanka, the workers have right to strike, but that is not explicitly mentioned in any labor legislation, but it is impliedly recognized as a right. But at the same time, right to strike has limitations also
Okay.
under many laws. So, if, when it comes to this statutory limitations, the unions can't violate those statutory limitations. Then it becomes a criminal offense.
Right.
Criminal offense. But I would say now we are in the 21st century, right? So when it comes to trade unionism also, it is something like a partnership.
Okay.
Right? So the employers and the trade unions and their representatives have to work together to promote the business.
Okay.
So otherwise we can't compete with other countries. We can't compete because so now when it comes to the trade unionism also, right? Actually, it is basically it is a partnership. Should be a partnership. So finally, if the business grows, then both parties will be benefited out of it. But at the, earlier you mentioned about this trade union termination and all.
Yes.
Right? In some places, what happens is because of their strikes and all, what happens is the business is affected.
Right.
Then when the business is affected, the employers have no choice. Then they have to reduce the number of workers. Then it comes under the Termination Act. Then finally, who is losing? Basically, I would say both parties are losing.
So also speaking a bit about the employer-employee relationship, it is a known fact that there are permanent employees and temporary employees. So you get private contractors, if you will. So the obligations that an employer has when it comes in a contract of service and a contract for service are different. Could you distinguish between the two of these for us?
Yes, but when it comes to contract of service, contract for service, generally we say the employees come under the contract of service.
Okay.
But the independent contractors come under contract for service.
Okay.
I will give an example. So we will take a canteen in a university. So the person who is running the canteen employs some people.
Okay.
These people come under the contract of service.
Okay.
But if you go there in the morning, you will find a person who brings cakes to the canteen.
Right.
And that person will deliver the cakes and goes to another place and deliver cutlets. He will go to another place and so that person is coming under independent contractors.
Okay.
But because the difference is, if they are employees, you have many statutory obligations. But when it comes to independent contractors, you don't have any of those things.
Right.
But here what happens is, in some places, the dividing line is very thin.
Right.
So because sometimes it is very difficult to differentiate a workman from an independent contractor. But the courts have developed many tests now to identify whether the person is a workman or an independent contractor. And also even there's a famous case from London, Uber London Limited. They also it was an issue. Right. So now when it comes to Sri Lanka also, now we have different forms of work arrangements.
Right.
So it becomes more and more complicated to decide whether the person is a workman or independent contractor. In certain situations, it's very difficult. But the problem will be, for an example, the employer decides that person is an independent contractor, not a workman. So he doesn't contribute for EPF, ETF.
Right.
But that person, after he leaves the place, he will go to the commission and complain.
Okay.
So the first issue will be whether the person was a workman or independent contractor.
And that decision lies with the courts.
Courts and the commissioner.
Okay.
If the commissioner decides the person was a workman, then what will happen? Because already the employer has taken the full salary and left the place. Right. Now, when it comes to EPF, now the 12% contribution from the employer will have to be contributed.
Right.
Then the 8% contribution from the employee, but the employee has taken the full salary and he has gone. But now it is the obligation of the employer to contribute that also,
8% also.
plus the surcharge.
Right.
So this is the issue now.
So, like you said before, sir, we are in the 21st century. Are these two categories of employment enough? Or should we look forward to a different category of employment with internet services and those kind of services coming into play?
Definitely there are many emerging forms, right?
Okay.
Even home workers, part-time workers, there are e-workers, and the person can be physically in one place and work physically in one country and work in another country. So, or one person can work in many countries at the same time, right? So these are the issues that we have. But at the end, the issue will be whether the person is a workman or employee. But then now we have, the courts have developed many tests and all. So we had to apply the test, and otherwise we had to go for a new test to make the decision.
So we know in Sri Lanka that laws are developed in two ways. Either courts develop these laws or passed through legislation. You were speaking about consolidating these legislations. Just a small question between the two. Do you think it will be more efficient for courts in Sri Lanka to develop more intricate tests and better ways of analyzing these relationships? Or would it be easier if Parliament simply passed amendments to the existing laws or consolidated the laws in a way that it can provide all of these provisions?
I think because when it comes to certain issues, because when it comes to Parliament, Parliament is the legislature.
Okay.
Parliament has to enact the laws.
Right.
But the courts have to make the decisions.
Right.
But when the courts make the decision, in certain situations they can go for judicial activism and all and develop the law. But the courts can't enact the laws.
Right.
So that has to be done by Parliament.
And of course, we are living in an age of statutes.
Yeah.
Thank you very much, Mr. Sarveswaran, for coming on our show and educating us on the labour legislation here in Sri Lanka. Of course, this is quite a general overview on the labour legislation. We can't quite cover it in total. We do hope to have you once again on our show. Thank you very much to all our viewers out there for tuning in to Biz First in Focus. We will catch you again, same time, same place, next week. Until then, take care and God bless.